Snacks Mills in the building.
I wasn't even thinking about me being on the show. I wanted to produce something for them.
Cool celebrity. Like if I went to the mall and stuff, people are like, oh,
The thing was, I didn't even know that anybody ever thought I was ugly.
We look like twins almost.
Okay.
She really wouldn't be
covering any more subjects related. So that's why you got the raw reaction. This is pathetic. It's pathetic. All right, guys, welcome back to the Sweet Pea Diaries. It's your girl, Sweet Pea, and I am back with another video. If you are a returning subscriber, welcome back to my channel. And if you are a new subscriber, welcome to the Sweet Pea Diaries. Be sure to like this video, share this video, but most importantly, be sure to subscribe to the channel. Deborah Smith, what's up, Tree Tap? What's up, girl? Monica, my mod, Susie Davis, Miss Jordan, Chelsea, Real Life with D Vlogs, Jasmine Barnes, Sweet Dark Chocolate. She says, girl, you on a roll. I just got off on your other line. Girl, I'm getting to, you know what I mean? I'm getting to the videos today. All right. I'm on a roll. All right. Yes, we are back again. All right. We are back with another video. Yes, absolutely. We are on a roll. 2 shows in a day. Thank you, Sweet Pea. You're welcome, guys. Now, you know I have to come with these updates because I pride myself when I am taking part in reviewing a case and when I'm doing the court documents and all that. If there's an update, I owe it to the people to bring it to them. I want to make sure that you are updated as soon as there are entries in the case. So I try to give you up-to-date updates as soon as they happen. All right. So we're just going to jump right into this. We know that Kenneth Petty and Nicki Minaj, it took them quite a while to respond to this lawsuit. If you've been under a rock and you don't know what this lawsuit is about, Jennifer Huff, who is a victim of Kenneth Petty from 1994, there was a violent rape that occurred between Kenneth Petty and Jennifer Huff. We actually we broke that down in my last video, and we showed the evidence where the California sex registry has actually showed that he used a knife. They entered that into their, I guess you want to say, docket, that he did use a knife. There was actual sexual intercourse. So we should not have any, we should have, it should be no discrepancies. Should be no question that this man raped Jennifer in 1994. Okay. Now, since Nicki Minaj and Kenneth Petty have become an item, Kenneth Petty has not registered as a sex offender. That is his punishment. That's his sentence. He is a level 2 registered sex offender. He's not a level 3. There was some discrepancy earlier today with a person that was in the comments Who said that Kenneth is a level 3? Kenneth is a level 2. He is a level 2 sex offender, which is why he has to report anytime he moves anywhere. So when he got with Nicki Minaj in 2000 and what is it, 18, 19? What is it? I don't know. Was it 19, 18? When he got with Nicki Minaj, he did not register as a sex offender in 2019 in California when he went out there and moved with her. Okay? So, in consequence, not registering, we found out that Kenny wants to be removed from the I hate saying that word, from the registry. I'm just going to say the registry. He wants to be removed from the registry because he doesn't feel as though he should have to report anymore. He's with Nicki Minaj. He should not have to report. He's above the law? Absolutely. He felt like he was above the law when he got with Nicki. He doesn't have to report. And because there's an agenda to get Kenny off of that registry, they began to harass Jennifer Huff. All right? Jennifer Huff was in the bushes. She was out minding her business, doing what she does. She had nothing to do with Nicki Minaj and Kenneth Petty until they started dating and putting on for display all on social media, wanting everyone to know that they were dating. They were sending messages basically that they're an item. He's with me now. I got the money. He's with me. I snagged Kenny. I got Kenny. I got Kenny. He's with me. I got Kenny. I got Kenny. They laid us down. We didn't know what to do. They laid us down. We was tooked. I got Kenny. I got Kenny. My name is Nikki. I got Kenny. My name is Nikki. We tooked. They laid us down. We didn't know what to do. We was tooked. I got Kenny. I'm the Bob. I'm Nicki Minaj. I got Kenny. Hey. So he's with Nicki Minaj. And they were sending messages. They were all booed up on Instagram. And then they go on Queen Radio and I don't know why they got on this topic. I really don't. But I guess they got on the topic of Kenny being railroaded, over a crime with a girl that he committed back in his younger day. And a fan says he was 15 and, he was 15, a kid or something. I don't know. But Nikki comes back and says, correction, she was 16, he was 15. They were dating or something like that. White is right. Okay, must have been a white girl. And then Nikki responded to the person like, yeah, basically, you're right, boo, because white is right. Black boys are always getting railroaded. I can't quote this shit, word for word, but you get the point. You get the drift. And we all been here. We've all heard it over and over. You guys know. I'm trying to outline it for the people that don't know about it. Just really trying to give people time to get here so we can lay out the real shit. Because when I show you these receipts that I came across today, documents obtained by the Sweet Pea Diaries show that Tyrone Blackburn has had enough. Tyrone Blackburn is through with the harassment and bullying of his client, the victim shaming. He says victim shaming is a disease and our country is plagued by it. He's had enough. So with this lawsuit, Jen is alleging that Nicki Minaj and Kenneth Petty have been harassing her indirectly and directly. They've been harassing her because they want to get Kenny off of this registry, because now that he is with Nicki Minaj, he needs to be able to travel. He needs to be able to be around people and go to events. He needs to be able to not have a link in his chain by having to report every time he moves. Report his every move. Call the sheriff if he wants to go to the beach, because sex offender registry, people that are on that list, They can't just move around freely. They can't go to public parks. They can't go to beaches. They can't do any of that. They have to contact the sheriff first before they go to these public places. So if you had that type of monkey on your back, wouldn't you want that shit off of you too? If you were with a celebrity now and you need to be able to travel in and out of state, in and out of the country, you need to be able to do all of this. You need to be able to do all that. You don't want to be able to pick up the phone because you got a report. You got to ask for permission. So they want him off of the registry. So they have been contacting Jen indirectly and directly. They've been using former friends and affiliates. They've been using them to contact Jen. They've been putting lawyers up to contacting Jen, wanting her to recant her story. So the story goes that she was raped by Kenneth Petty. He used a knife to rape her. He led her to an abandoned home in New York and he raped her. In Queens, he raped her. She was 15 years old. Kenneth Petty was 16, on his way to being 17, because when he was convicted a year later, he was almost 17 years old. Months later, should I say, he was 17 years old. So Kenny was 16 years old when this happened. Okay? He was 16. Now, oh goodness, it's just so much. So much. It's so much. Okay? It's so much for my mind to grasp. I've been talking about lawsuits all day. I just got finished doing Tasha K. And now I am on to this one. So I have to make sure that I got it all. You know, this is not easy. So for the people that drag me and for the people that do not like my commentary, you try doing 2 videos back to back based on court documents. Okay? So yeah, we understand that this happened. And so all those years ago, Jen went through so much with her family. She was, they wanted her to recant because they were being bullied in the neighborhood. You know, so once this happened, you know, people in the neighborhood were dropping by Jennifer's house and they were getting phone calls and all of this. So she was being pressured to recant her story ever since this shit happened to her. Okay. From the time this happened, she has been victim shamed. She has been accused of being a liar. She has been accused that she just wants to put this on. Why would a 15-year-old girl want to accuse someone of raping her at knife point? What is she standing to gain from that? That's just where I'm lost at. So Kenny now is saying that, yes, we did have sex that day, but it was consensual. It was consensual. We did have sex that day, but it was consensual. I didn't rape her because we were an item. We were childhood sweethearts. Okay, so if you were childhood sweethearts, then I need to understand what childhood sweetheart needs a knife to get his sweetheart to have sexual intercourse with him, to have an encounter. If you're her, sweetheart, you've already done this with her before. So what do you need a knife for? What child, 15, 16, needs a knife to have sexual intercourse with another 15-year-old, 16-year-old? Why was there a weapon involved? So now that time has went by and they are adults, Kenny is tired of registering. Kenny wants this off of his record. But what people do not understand is that Jennifer is not the one that pressed charges against Kenneth Petty. So during that 1994, back during that time, the DA picked up the case. Jennifer, even if she tried to recant her story, the story goes that she went down to the courthouse trying to recant her story. She went down to the courthouse trying to recant her story because her family was making her do so. Prior to, now we also left out a point, prior to this whole court day, the infamous day that Jen went down to the court and tried to stop them from prosecuting Kenny and wanted to recant, and she seen the DA in the hallway on the steps and whatever. She had also been taken down to the DA's office by Kenny's parents. They were posing as her family, posing as her aunt and uncle. They were posing as her family members, taking her down there to get her to recant. And some people say, where was Kenny's parents? I mean, who was pretending to be Kenny's parents while Kenny's parents were with Jen trying to make her recant? That is very believable. That I don't understand why that wouldn't be believable to anyone. If they were going to her house, calling her house, they were showing up at her house trying to make her recant, the family allowed them to take Jen down there and pose as her family. They absolutely did. They were in on it with the Pettys. They took her down there and made her attempt to recant her story. But that DA knew what was up, and the DA wasn't buying it, which is why the DA picked up the case. Because if the DA had not have picked up the case, that shit would have been able to, would have been able to go free, and nothing it wouldn't have been addressed. He would not have been prosecuted. The DA picked up the case because they knew this was a bunch of BS. Anyone ever stop to think, why did the DA pick up the case? Did that enter anyone's mind? Has that entered anyone's mind? Why did the DA pick up the case? I would love to see Barb's, because I left the chat open for people that are on the other side. I would love to see anyone that has a difference in opinion, and please be respectful. If you want to have a debate, if you would like to talk about it, we can do that at the end of this video once I get through these court documents. But what I need to know is, why did the DA pick up the case? Why didn't they leave it at Jennifer against Kenneth Petty, him being the perpetrator and her being the victim? It's not because they were kids, because then it could have been in juvenile court. They picked that case up because of the violence, the level of violence. It was done with a weapon. There was actual intercourse. The evidence that they had, absolutely. The evidence that they had, and the fact that it was violent. It was violent, which is why they picked up the case. And they already saw the activity that the families were trying to get Jen to recant her story. So when she got down there and she tried to, I want to recant, I want to take it back. The judge tells her, go see the DA about that. They said, go see the DA because there's nothing Jennifer can do at this point. Once the DA takes over the case, the victim, her statement, none of that. No one cares about any of that. They will use her statement. They'll use it during court. But she can't have any bearing or any weight on having the charges dropped. Nothing she can do. Nothing she can do. So that's why the case was not dropped. And if she didn't recant the story as she was being made to, because the DA already took the case up. So whether we like Nicki Minaj, whether or not we like Jen, whose ever side we're on, you have to have common sense. Common sense gotta outweigh your like and your pick-me stance. The facts are staring you right in your face. It's obvious. So now that we're here and we're now at this lawsuit, people are saying that, so I don't understand why the DA offered him a plea deal if they had all this evidence against him. So this is what usually happens in a child's case. They're not trying to have a 16-year-old, his life destroyed. They don't want you to be in jail for the rest of your life. So they pleaded down and said, take the plea deal. We don't need the expense of a trial because you're going to lose. You're going to lose. So just take the plea deal, go on about your life. 4 years, you'll be out. We're hoping that you don't go on to do anything, commit any more crimes. We're hoping that. But what happened? He went on to commit more crimes. So that's usually what people do when they're trying to help you out. Contrary to popular opinion, the DA, the law, they're not trying to railroad kids. Yes, all cases get offered a plea, even a murder. Most people get offered plea deals. Plus, he didn't want exactly. No one wanted 20 years. He was facing 20 years. So what would actually happen? Okay, so let me explain it so that it makes sense to people. All right. So let's just say we're Kenny, right? We did this crime. And at this point, it is, and when we looked at the charges on the sexual offender registry, you guys saw that it said attempted rape in the first degree, because what it was at first was rape in the first degree. Okay? It was rape in the first degree. There is no such thing as attempted anything. Attempted comes into play when they're trying to plead it down, or when they're trying to, lessen the brunt of the charges or lessen the consequence. And the reason why this is true is because attempted rape carries no sexual intercourse. If it was attempted rape, it would have been no sexual intercourse. Look it up yourself. Attempted rape means that no sexual intercourse happened. Well, we know that that's not true, that there was sexual intercourse, because when you look at the paperwork at the sexual offender registry, it says actual sexual intercourse. So they put that because they're letting you know we pleaded this down for him, to help him, because he was a child. He was a child, and he said, is there a plea? His lawyers, the public defenders, they worked with the DA, and they said, okay, this is what we can do. You go ahead and you admit to it. You plead guilty to it. We'll give you 1 to 4. We'll put it down to attempted. The reason they put it down to attempted, because attempted carries a max of 4 years, 1 to 4 years. They can't leave it at rape, because that is 20 years. Okay? If they leave it like that, when they try the case, they have to consider the 20 years. So you have to have everything match up. The crime got to match up with what they can punish you with. You know what I mean? So you can't leave a charge at rape and then say 1 to 4. It don't work like that. Rape doesn't carry 1 to 4. Rape carries up to 20 years to life. So they have to plea it down to a lesser crime so that they can give you lesser time. So you guys, you can't go into the justice system thinking that it's bad. That's unfortunately, that's Black people. We think that, the justice system is just out to get us because of the experiences that we have. But contrary to popular belief and opinion, they don't want to send a child away for the rest of their life. So this is he's before them. He's with his public defender. They're like, listen, we can get you a plea deal. We can plea it down. They can plea it down to attempted rape so that you will only do 1 to 4. She also never said it didn't happen, but I want to drop charges, but it was too late. But it wasn't too late, because it didn't matter whether she dropped the charges or not. She wasn't the one that had the charges. That's the public opinion. That's where this public opinion shit comes at with these bloggers. They be talking so much shit and putting out so much false information. Jen never pressed charges. The state of New York pressed charges. So she can't drop anything. So that's where, the false narratives begin right there. Jen is not the one that had the lawsuit against Kenny in the first place. Jen is not the one that is, responsible for him getting 1 to 4. He committed the crime against her, and the DA picked up the case. Jen no longer is involved in it. She's no longer involved in it. That's why when she say, I want to drop the charges, she didn't realize there's no charges you can drop. Her family didn't even realize that there's no charges she can drop. She's nobody at this point. She wasn't even needed as a witness, which is why she was not called in for court. She was not even needed there. The DA was trying that case without her. They don't need the witness. They don't need the victim. They don't need any of that. They took over the case. Again, go do your research and go learn about, not anyone specific, I'm just saying in general for everyone. Go read up on the difference between a DA taking the case and, the actual victim. Because if you look at the paperwork and you look at the charges, it's Kenneth Petty being tried by the state of New York, not Kenneth Petty versus Jen, the victim. Jen's name is nowhere on the paperwork. It is the state of New York against Kenneth Petty. Exactly. Once the state got it, it's a wrap. It's nothing you can do about it. Once they pick it up, that's it. And they picked it up and he pleaded out. And as far as Kenny goes, his record, that's what he does. He pleads for everything. He pleads for everything. So that's what we have to, we got to consider before we even break any of these paperwork apart. Jen is not the one that was in court against Kenny. The state of New York filed these charges. The state of New York took Kenny to court over this offense. The state of New York, not Jen. So now let's get down to this paperwork, okay? So we know that, we all know what's going on. We know that Nicki Minaj and Kenneth Petty were served this lawsuit. So they have been saying from day one that they did not get the paperwork, that the process server did not serve them, okay? I just went through this not too long ago where the process server says he served me and he didn't serve me. He served someone at my home. He didn't serve me, but they considered it served because it was at my residence. So they're not going to get away with that. It may look like it to you right now because you guys are out in, YouTube land and a lot of people don't understand the law, but they can stretch this out as long as they want and they can argue that shit back and forth. But if it was on your residence and the process server felt as though who he left that paperwork with, if he felt like it was your security guard, if he felt like it was you looking out at that window, he served you on your property. He served that paperwork at that property. There are rules around serving, and he fulfilled those rules. So regardless to whether people want to say he didn't put it in their hand, it does not go like that. Unfortunately, that is not the way the law around serving papers go. There are certain parameters that, if they are met, constitute a legal serve. So we're going to find out that that process server, that serve is going to be a legal serve. So they're trying to debate that they were not served. So the lawsuit should be thrown out. Kenny was late. Nicki was late. No one has legally still has yet to respond to this lawsuit. That's another. All these other bloggers. That is another narrative that is being spun. That Jennifer, she filed this lawsuit. And that Kenny and Nicki has responded because they have lawyers that have entered into the case. They got high-priced attorneys. They still have not responded to the lawsuit. They have not stated what they intend to do. They have entered in legal paperwork that shows this is going to be my lawyer, and my lawyer now is asking for more time to respond to the lawsuit. We are arguing certificate of default on both of them. They answered the certificate of default. Kenny answered to that and said, I don't want this to be the outcome. We are disputing the certificate of default, which was entered because he did not respond to the lawsuit on time. Whenever you don't respond to a lawsuit on time, a certificate of default is entered by the court clerk, not the judge. The judge does not issue a certificate of default. The court clerk does. So for Nicki Minaj's certificate of default, when Jen and Tyrone went down to the courthouse and said, hey, Nicki Minaj has not answered to this lawsuit. It is expired. Her time to file has expired. We would like to enter a certificate of default on her behalf, on Jen's behalf, so that she will win this because Nicki has not responded. They filed that paperwork, but the court did not do the certificate of default for Nicki because they said they did not have enough staff. They did not get the paperwork together. They didn't have enough staff. So when Tyrone went down to the courthouse to pick up some other paperwork and enter in some more motions, he said, where's my certificate of default for Nicki Minaj? I'm entering one now for Kenneth Petty. They did the one for Kenneth Petty that day, but not Nicki Minaj. Already playing favoritism. I smell a rat somewhere. How were you able to have enough staff to do Kenneth Petty's certificate of default, but not Nicki Minaj's? Their argument, they didn't have enough staff in the court clerk's office. So Tyrone filed a motion with the judge that the court clerk and not having enough staff should not be held against his client. That shouldn't have anything to do with the certificate of default, and they feel as though it should be issued on the behalf of Nicki Minaj. So we are waiting to hear from the judge still on that motion. We still have not heard on that motion because why? Because now the lawyers are throwing more and more and more paperwork. They're throwing more and more motions, trying to stretch this shit out, trying to keep everyone abreast with all this paperwork. So now they have filed another declaration. They filed another declaration, Kenneth Petty and his attorneys, because you have to understand, like I told you, Kenneth Petty and Nicki Minaj are both being represented by two separate attorneys. I told you that that was going to happen because they want to distinguish between the rape and harassment and the whole intimidation situation, which is why Jennifer, her charges for the rape and the sexual battery is not applying to Nicki Minaj. We went over that in our last video, and we showed that Kenneth Petty and Nicki Minaj have different charges. So that is another false narrative that these bloggers put out in these YouTube streets. That's another false narrative that we have debunked. Jennifer is not suing Nicki Minaj for the rape in 1994. She's suing Kenneth Petty for the emotional infliction of distress that has caused her over the years. And the fact that you are now intimidating me and harassing me because you want to be off of the sexual offenders registry. So now we have these declarations now where Kenneth Petty has asked the judge to hear his side of things as to why the certificate of default should not be granted. Because Jennifer, she was able to get that against Kenny because he didn't answer to his lawsuit in time. So the clerk issued the certificate of default for Kenny, but not for Nicki. So now where this stands, both of those motions are sitting at the judge's lap, and we are waiting to hear from the judge. But in the meantime, other motions are being filed. They're continuing to just put forth all this paperwork. Kenneth Petty has put forth a whole declaration and motion saying that why his certificate of default should not be honored because Jen's case really doesn't have any merit. She's only suing him now because He has money because Nicki Minaj is rich and famous. He has money, so she's only suing because she's jealous and she wants money. Okay? So now Tyrone Blackburn has had enough. That's where we have been, and that's where we're at. Tyrone Blackburn now has had enough. He said, this is it. I'm done with this shit. I am sick of this victim shaming. I'm tired of these attorneys and the defendants victim shaming my client. It is pathetic, and I'm sick of it. I'm grabbing the documents, guys. He said it's pathetic, and I'm sick of it. So here is Tyrone Blackburn's response, because Kenneth Petty entered in a response to the judge saying, I don't think that Jen should be able to win this case, and the certificate of default should not be granted. So Tyrone comes back with his response to Kenneth Petty, and this is what he has to say. All right. Memorandum of law in support of opposition to defendant Kenneth Petty's motion to vacate certificate of default. Tyrone's preliminary statement. He says, I'm going to blow it up a little bit for y'all. All right, that should be a little better. All right. Okay. He says victim shaming is a disease that permeates every socioeconomic class in our society. While the Me Too movement has made tremendous strides in this regard, victim or accuser shaming or blaming is an enormous deterrent to women coming forward about sexual assault or rape. Thus, victim shaming is especially detrimental to women of color, who are already less likely to report being raped than white women. That being said, this case stands to help women of color who have been abused and those who have been disgracefully shamed and blamed into not coming forward. And importantly, this case could demonstrate the profound consequences of social media bullying by celebrities with millions of followers, especially with respect to matters of great psychological significance. Defendant Kenneth Petty, aka Zoo, is correct about one thing. The reason for plaintiff Jennifer Huff filing the instant action 27 years after defendant Petty raped her is obvious, but not for the reasons that he stated. Rather, defendant Petty and his wife, Onika Tanya Mirage, Nicki Minaj, engaged in a scheme to defame, shame, harass, threaten, bribe, and coerce the plaintiff into recanting the true events that occurred on September 16, 1994. After defendant Petty was arrested for failing to register as a sex offender, the defendants used one of defendant Petty's gang members to contact the plaintiff. As a result, defendant Mirage, wife of defendant Petty, was able to speak with the plaintiff by phone to encourage her to recant her claim that defendant Petty raped her. Now, we are right there where everyone, hey Treetops, I see you guys. Hey 901 Diva, hey Jesse, hey USA Army Brat. I was reading the document, so I did not see you guys come through, but I see you now. Hey guys, I tell you, when the treetops come through, honey, it's like a forest. Hey, you guys, love you. Hey, Snooky. All right, so yes. Okay, so we're gonna stop right there because this has often been a point of debate where they like to say that Nicki Minaj, how did she get in contact with Jen? Did Jen call Nicki Minaj? Or did Nicki Minaj call Jen? Jen has always said that they went through a third party, which was Black. The documents state right here, after defendant Petty was arrested for failing to register as a sex offender, the defendants used one of defendant Petty's gang members to contact the plaintiff. As a result, defendant Mirage, wife of defendant Petty, was able to speak with the plaintiff by phone to encourage her to recant her claim that defendant Petty raped her. Because defendants were unhappy with the result of defendant Mirage's call with the plaintiff, they used the same person to post a videotaped death threat to his social media account. Additionally, defendant Mirage and defendant Petty have used the former's fame and wealth from her career as a multi-platinum selling and Grammy-nominated music artist to permeate plaintiff's life with memories of this day by publicly lying about the events that occurred. So you don't think to publicly denounce a person being raped, to publicly shame a victim and state that what happened to her did not happen, to undermine the validity of her statements, to somehow lessen the crime by suggesting that they were just kids. This doesn't affect Jen in any way as a victim? Wow. Additionally, defendant Mirage and defendant Petty deliberately and willfully failed to timely respond to plaintiff's amended complaint in this action. Repeatedly, since appearing in this action, defendant Mirage's counsel, who is acting in concert with defendant Petty's counsel, has pompously stated the court will not enter a default judgment against her. So you see right here, this statement is stating what I just told you. They still have not responded to this lawsuit. They're responding to default judgments. They have pompously not responded, meaning they are deliberately, Tyrone said, deliberately and willfully failing to respond to the complaint. They still to this day have not done so. They are issuing mumbo jumbo, a default judgment. They are answering to a default judgment and why it shouldn't be. They're entering briefs about a default judgment. Still has not stated what they plan on doing with this lawsuit. Period. Contrary to the assertion by defendant Petty's counsel, plaintiff is not improperly rushing to obtain a default judgment against Petty. Instead, on September 15, 2021, defendant Petty was personally served with the summons and amended complaint at his and defendant Mirage's home in Calabasas, California. On October 6, 2021, they were both required to interpose a response to the amended complaint. Incredibly, despite both parties' ample experience in court and the enormous coverage this action has received by the media, they both failed to timely respond. Thus, on October 11, 2021, even after giving the defendants 5 extra days, plaintiff filed an application requesting that the clerk of court issue certificates of default judgment against both parties. Then, on October 13, 2021, defendant Mirage's counsel suddenly appeared. Judge Bernstein sought an extension to file an answer to motion to dismiss. Mr. Bernstein offered no excuse or explanation for his client's default, but rather expressed what has become his mantra, that defendant Mirage will prevail on a motion to set aside her default. Mr. Bernstein, like defendants, arrogantly believes the rules do not apply to him or any of his clients. As such, there existed no reason to afford defendant Mirage an extension. Yet, like Mr. Bernstein, defendant Petty's counsel baselessly argues that common courtesies amongst attorneys bound plaintiff's counsel. It is comical, however, that this is even mentioned in defendant Petty's motion papers. Defendant Petty did not seek an extension to respond to the amended complaint. Hence, this is, by an interpretation of the analogy, grasping at straws, and further evidences the collusion between defendants' counsels. On October 19, 2021, because their certificates of default judgment had unusually not yet been issued, plaintiff's counsel Tyrone Blackburn appeared at the clerk's office. A few hours later, a certificate judgment was issued against defendant Petty. Still, at this time, defendant Petty had not even filed a notice of appearance. On October 25, 2021, defendant Petty's counsel finally filed a notice of appearance, now with nothing but self-serving, baseless, and conclusory declarations from defendant Mirage, Mr. Bernstein, and himself. Defendant Petty wants the court to believe that he did not willfully fail to timely respond to the amended complaint. At bottom, defendant Petty offers the following three reasons for why the court should vacate the certificate of default. Service was improper. There are technical deficiencies in plaintiff's application for the certificate of default. And the three main factors of good cause, willfulness, and meritorious defense and prejudice to the non-defaulting party weigh in his favor. The facts and evidence, however, suggest otherwise. First, defendant Petty was properly and personally served with the summons and amended complaint. This was sworn to by plaintiff's process server, Robert Diaz, in the proof of service or affidavit of service, and his declaration in support of plaintiff's opposition to the instant motion. Defendant Petty's declaration is so carefully crafted in an attempt to avoid perjuring himself. However, despite his valiant effort, defendant Petty threaded the needle too thin. Specifically, defendant Petty perjured himself by swearing that no one tried to hand me the summons complaint, amended complaint, or any other document in this litigation. Further, if defendant Petty was not served, his declaration in support of the instant motion is devoid of facts concerning how he learned about the amended complaint. Clearly, for these reasons, the affidavit of service constitutes prima facie evidence of proper service. The others described below make it clear that defendant Petty was properly served and has perjured himself in this declaration. Second, in contrast to defendant Petty's argument, plaintiff's application for certificates of default judgment against the defendants is complete and in accordance with Rule 55.1 of the local rules. On September 17th, plaintiff filed the affidavit of service for both defendants. The affidavit of service demonstrate that service was properly effectuated on the defendants by personal service on defendant Petty. Even if the affidavit of service does not reference that the amended complaint was served, such as demonstrated by the Diaz declaration. And the fact that the defendants knew about the amended complaint. By his own admission, Defendant Petty was supposedly attempting to retain counsel to respond to it. So what they're saying here is if you are not properly being served, you said that Diaz did not serve you the amended complaint, then how did you know about it in order to gain counsel? How did you know about it in order to even respond to it? Further, even if there is one in the plaintiff's application, a mere technical defect is not a basis for vacating the certificate of default judgment. Nonetheless, the certificate of default judgment is nugatory without the entry of default judgment. To that end, plaintiff's motion for entry of default judgment cures any potential defect in her application. As such, this is not a basis for vacating the certificate of default judgment. Third, the facts and evidence unquestionably support the factors considered for entry of default judgment weigh substantially in the plaintiff's favor. The three factors generally considered by the courts are willfulness in failing to timely respond, whether the defaulting party has a meritorious defense, and prejudice to the non-defaulting party. As more fully described herein, all three of these factors weigh in Jennifer's favor. Therefore, as more fully described herein, the court should deny Defendant Petty's instant motion in this. Oh, God. Like, just let it go. You guys know you did what you did. It's so funny that these people will go to such lengths because, if we were to, like determine that they really were doing all this, people are going to look at you different. Like, so you really were threatening this girl because you wanted to get your husband off of the sexual offender registry. I mean, that shit is common sense. But to go as far as to accuse a civil service worker of not doing his job, someone that has probably prided themselves in doing their job just to get yourself off of a crime that you know you committed. But let's talk about this. The fact that they know they did what they did, but they're defending it. People in the streets know that they did what they did, but yet they're defending them. Let's not act like we don't see these people on the internet and on social media acting like criminals. Criminals, pull up. All of that. That is not reformed criminals. Those aren't rehabilitated criminals. Those are not productive members of society. Those are people that want you to believe that they are criminals. They want you to believe that they're goons, that they're thugs. And goons and thugs commit crimes. So why are we defending goons and thugs? It's the audacity and the contradiction for me that people would actually defend thugs. Hold on one moment, guys. Yeah, so I'm sorry about that. I had to answer a phone call. So yes, I mean, they want people to come away thinking after watching their social medias on the internet that they're thugs. They commit crimes. That's what thugs do. They murder, they maim, they victimize people. So how are you defending a person that is on the internet telling you that they're a goon? A woman that's telling you she's queen of the goons. A woman that has no problem with you knowing that she's part of a goon squad. She prides herself in being part of a goon squad. She travels with goons and constantly makes reference to being a goon. So why are we here? Why are we here? Please, someone tell me why we're here. Why are we even questioning it? So the factual background, the relevant facts in support of this opposition to Defendant Petty's instant motion to vacate the certificate of default judgment against him are detailed at length in the declarations of Plaintiff Huff, Robert Diaz, and Tyrone Blackburn and Stephen Gordon, all exhibits to such declarations and the amended complaint. To avoid redundancy, such relevant facts are incorporated by reference as if fully stated herein. The argument: the court has jurisdiction over Defendant Petty because he was properly served. And we're not going to go through all of that. They're just saying that he was properly served, and they're explaining what it means to be properly served. They're saying that you have jurisdiction and over him and jurisdiction to consider the default judgment because he was properly served. Number two, the plaintiff properly requested the certificate of default judgment. This paragraph goes into the process and the steps Jennifer and Tyrone took in getting a default judgment, that they did it all properly according to technical rules. They went down to the court, how they process, all of that. They are stating they followed the rules. Number three, the certificate of default should not be vacated because the factors for default judgment weigh substantially in the plaintiff's favor. They're stating that you should honor this certificate of default because everything that Jen was supposed to do and the factors that are inside of this default judgment, it is in Jen's favor because they did not respond to the lawsuit. They didn't adequately give, when they did respond, all they did was give notice that this was going to be their attorney. So they did not properly answer to the lawsuit. So this substantially weighs in her favor, and they should grant the certificate of default. And that's just more, that's what these paragraphs are explaining. All of that, all their evidence to support that. Mm-hmm. And then number four, plaintiff alleges all plausible causes of action in the amended complaint. To state a valid claim, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its fact. To state a claim for intentional infliction of emotional distress under New York law, a plaintiff must plead extreme and outrageous conduct, intent to cause or disregard of substantial probability of causing severe emotional distress, a causal connection between the conduct and injury, and severe emotional distress. And they're going all into here. Here, Defendant Petty's conduct towards Ms. Huff was extreme and outrageous, including but not limited to sexual assault, rape, harassment, and intimidation. This includes recent harassment and intimidation through Defendant Petty's friend, associate, and fellow gang member, Black. The actions go beyond all possible bounds of decency and are atrocious and utterly intolerable in a civilized community, satisfying the first, the second, and the third prong of the test presented. An assault is an intentional placing of another person in fear of imminent, harmful, or offensive contact. A battery is an intentional, wrongful physical contact with another person without consent. Indeed, the slightest unlawful touching of another constitutes battery. Here, defendant committed battery against Ms. Huff as he intentionally engaged in unlawful, intentional, and offensive touching or application of force to Ms. Huff's person. In New York, negligent infliction of emotional distress requires a showing of 1, extreme and outrageous conduct, 2, a causal connection between the conduct and the injury, and 3, severe emotional distress. In the time preceding this criminal act, Defendant Petty has enabling parents, associates, legal team, gang affiliates, agents, and servants worked in concert and engaged in conduct that rose beyond the threshold of extreme and outrageous. The extreme and outrageous conduct are as follows: stalking Ms. Huff, stalking Ms. Huff's 22-year-old daughter, stalking Ms. Huff's family members, causing Ms. Huff to move residence on multiple occasions throughout the years, bribing Ms. Huff into recanting her rape claim, threatening Ms. Huff with physical bodily harm if she did not recant her rape claim, and threatening Ms. Huff with death via social media posts. As a result of the conduct detailed above, Ms. Huff has suffered and continues to suffer physical injury, psychological injury, emotional distress, physical manifestations of emotional distress, embarrassment, loss of self-esteem, disgrace, humiliation, and loss of enjoyment of life. Now, I need to know why anyone finds that so hard to believe. If you are a victim and you have people out in the community that don't even know you, you have people in the YouTube community, people in the Instagram community, people in Twitter, everywhere. These people do not know Jen, yet they're in her DM, they're in the comments calling her all kinds of disgusting names. They are sending her death threats. It goes on and on. We can just imagine what they're doing. And no one thinks that that's intentional infliction of emotional distress. You don't believe that Nicki Minaj understands that the bars are crazy, that all she has to do is make a subliminal post and they don't understand what she's talking about and they don't jump right on it. She knows exactly what she's doing when she makes these subliminal messages and she does this subliminal whatever this shit is. Whatever that fucking noise is, I can't do it with my tongue. Who wanna? I can't do it. Normal people can't do shit like that. Normal people can't do bird calls and roll their tongue. I don't know how to do it. But she knows exactly what she's doing. And the people that are following her and are listening to her, they know what she's asking them to do. So you don't believe these claims? You don't believe what Jen is saying? That it can actually occur. Like, miss me with that shit. They are actually doing that shit. And Jen is actually being humiliated. She's actually being psychological, physical injury, emotional distress, all that shit. I believe it. Period. Because I know what they do to me just with YouTube videos. So please. So the conclusion: for the preceding reasons, Defendant Petty's motion to vacate the certificate of default judgment should be denied. In the event the court is inclined to grant Defendant Petty's motion, plaintiffs request the court holds a traverse hearing so that Defendant Petty and Defendant Mirage can testify under penalty of perjury to the validity of their declarations denying service or process and their assertion that they were seeking out legal counsel. So Tyrone is stating that if the judge should find that he is not going to grant Jen the certificate of default, they are asking that Kenny and Jen be brought into court and made to swear and testify under penalty of perjury that they did not get served by the process server and that they were seeking out legal counsel. He wants them to swear to it. I know that's right. Tyrone. Tyrone said, if you should believe and decide not to grant her the certificate of default, we need them to come in here and swear on the Bible. Swear on the Bible that you did not get served. So this is just Tyrone Blackburn's declaration. We've read this before. This is just his declaration as to what has happened up until this time. Now, this looks to be LexisNexis. This looks to be some type of background check. Deeds. This is the home. All right, let's see. What is this, honey? We got some receipts. Oh, what Tyrone done entered in here, honey? Okay, so what is this? Mm. Oh, this is some. Oh, this is a house that Kenny bought in Baldwin, New York in 2010. Okay, can we turn it around? Okay, 967 Middle Bay Drive. So I guess this is his home that he owns. He bought that house in 2010. Sale price, $500,000, $525,000. Woo! So, honey, what is he trying? Oh, and then this is the declaration of Robert Diaz that he served them. Oh, honey. And they put that inside of that paperwork. So that's yeah. So I guess that's just basically what's in this brief, honey. Everybody's declaration. You've seen all the receipts. Child, I don't know what that had to do with I'm like, what they got to do with anything? That's what I need to know. Like, huh? Tyrone, what you doing? What you doing, boy? But honey, that's a cute little house. That's a cute little house. That's a cute little house, honey. Now, we do have a response. We do have a response from Kenny's side. We do have a response. All right. Now yes, he's demonstrating his assets, basically, child. Yeah, maybe they might want to seize it, right? They might want to put a lien on that thing. Now we do have a response from Kenny's side. So let's just jump into that briefly, and we're going to see what Kenny and his attorneys have to say. Right? I told you this was going to be a long update because there was two different sides. There's always two sides to a story. So we do have Kenny's attorney's response. All right. Oh, Lord. Child, I done got Tasha K's thing up here. I told y'all I got too many darn court documents. Let me get this one. I still had Tasha's stuff up. All right, here we go. All right. So now, oh no. Oh no. This is not that. Hold up. That's actually Stephen Gordon. That's actually Jennifer's second attorney. His little declaration. I wasn't reading that, child. That's just too much. I'm not reading that because it's the same thing. He's not saying anything any different than what Tyrone is saying. So I don't think we need to read Stevens. But let me check and see. I do believe that there was a response from Kenny's team as well. Let me just check real quick. If there is, we will read it. If not, we gonna get up on out of her. It's getting out of her. All right. Let's get it. All right. Let's see. Oh no. No, there is not an update. There is no response to Tyrone. This one is already, we read all those. So Kenny's team hasn't said anything. Nope. A video of what? Nope, there is no response to Tyrone's declaration. Nope. So we're basically just sitting here waiting on the judge. And what video, sweetheart? So yeah, we're basically just waiting on the judge now. We're waiting to see if he is going to issue this default judgment, if he's going to let it stand as far as it pertains to Kenneth Petty. Nicki Minaj's default judgment, we're waiting to see if they're going to even allow that to even be a thing. Because as you know, that one never was issued. That was never issued. I don't know I don't know. I don't know what you guys are saying. You guys are talking in code. I don't know what you're saying. I don't know what you're talking about. What is HS? Who's HS? What website is she getting these documents from? Pacer? Would you like to see? Would you like to see, Tammy? Would you like to see? Oh, Hot Shot. Oh, okay. Girl, I'm like, who is HS? Who is HS, girl? Okay, Hot Shot. So there's a video on, and I know Whack T. I know you guys talking about Black T. But why would Black T be exposing Nikki? Isn't that her girl? Doesn't she like Nikki? So why would she be exposing Nikki? And Tammy Will, what website is she getting these documents from? We get our documents. All our documents come from Pacer. They come directly from Pacer. So these come hot off the press. They are straight from the courtroom, straight from the courthouse. That's right. We get them straight off the press. These are not third-party documents. These are not from a free website. These are from Pacer. Yes, ma'am. So here is my screen. You see that? Pacer. You see it? U.S. District Court, Eastern District Court of New York. Civil docket case for this case. Here is the logo and the seal. This is the entire documents that are all on here so far that have been entered on this case. That is where we get them from. Okay? Got it? They used that video where she was going in on Nikki when she called in Armand's show, but we'll see what H said. She exposed. Oh, she don't mean to expose her. Y'all crazy? Yes, but yes, ma'am. All of our documents are real. They are authentic. They are not, they're not from a third party. I don't know if anyone knows what Pacer is and if you even knew that. A lot of people don't know that you can get free access to, court documents. However, Pacer is you have to pay for Pacer, so you have to pay for an account. So you have to register for an account. It's not something that you can just go out and get. So you have to, it's not like you can just go do this today and get access today. It's a whole process. So you would make a username, like you can make a name or whatever, but then you have to go through motions to get this. Like I didn't just get this overnight. I don't know if I'm lagging or not because I'm not on, I'm not on camera, so I can't really see what's going on. all I can, I'm not on my what's the name? And a lot of times when I share my screen, sometimes that happens. So yes, ma'am, that's where we get our documents from. We get them from Pacer. When we do the Tasha K, Cardi B lawsuit, we also get the documents from there. So yeah, I'm not one of those fake ass bloggers and fake ass people that do stories with fake documents. If I'm gonna do something, you know what I'm saying, I do it right. I would never get up here with fake and phony records just to do a video. It's not that deep for me. You feel me? So yeah, I go to the source and get my shit. And I mean, that's what people know me for. That's what they know my channel for. They like Sweet Pea's receipts are going to be real. They're going to be authentic. They're not going to be some fake ass shit. So, Tammy, I hope you stay, boo. I hope you come back. I see you come every now and then. And, oh, Susie says, how's the new puppy enjoying being? Yes, he is. Evan done got big, honey. Evan done got big. He is no longer a puppy. But they are in age. They are both puppies in age, but Evan is a little smaller. I'm gonna put him on camera. Once I get my studio together, I'm gonna put them on camera so you can see how big they got. Charlie is huge. The white cream, so you guys know I got two ever since we had the major accident, Apollo, God bless his soul, God rest his soul, my angel baby. So we replaced him actually with the white one. And then I got the brown one as well. Because Charlie was so big when I went and got him. And I felt like I got robbed of the baby experience. So I went and got an even smaller one. So that I could still have my baby experience. Because Apollo was 10 weeks, when we got him. And he was such a baby. So when they killed my baby, we missed out on the baby experience. When we went and got Charlie, they said he was 15 weeks. Charlie wasn't 15 weeks. Charlie looked like he was about 20 weeks, maybe 25 weeks. 25 weeks. Okay? 25. So, yeah. Hold on for a second, guys. Yes. They are golden retrievers. Charlie, the white one, he is a English cream golden retriever. So he's all white with little blonde undertones. He's so sexy. He's so fine, mommy baby. And then I have Evan. Evan is also a golden retriever, but he is so golden. He's so golden and orangey, golden. He's so handsome. But he is a little bad butt. He's the bad one. He jumps on Evan, be tearing Charlie up. But then when you look at them when nobody is watching, honey, they be cuddled up. They be cuddled up and cuddling and they sleep together. They eat out the same bowl, even though they both have their eating stations where there's one supposed to eat here and one's supposed to eat there. They both like to eat out the same bowl. So they, no matter where I put, if I fill both of them up, but they will not eat out of it. They got to eat out the same one. So, child. Deborah Smith says, Sweet Pea, not to change the subject, when I thought about you and I just laughed my ass off as soon as I seen Cardi B. Girl, you guys already know that I got a show. That's going to be my first show. I'm going to be doing that because I got to rub that shit in. I got to rub that shit in Tasha K's face. So we are definitely going to talk about Cardi and her looks and how she was serving. And we have to do a review of the American Music Awards. So you already know I'm going to do that with my new set and my new shit. And I'm going to be looking good. And I'm going to be talking shit about Tasha K. Because Cardi B was serving. I was so proud of her. I'm so happy that she got to do that. So yes, we are going to be doing a show on it. So that's coming. So watch for it. Isn't it so sweet when you can, yes, it's the best when you can brag on your babies, right? I love them. Girl, thank you. I am the queen of receipts. You know it. So I love you guys. I'm getting ready to go. I'm getting ready to get up out of here. You hear my phone. It is going off. It is off the chain. They like, girl, you done did 2 videos. Let's go. Get your ass off that computer and get your ass in this kitchen. So I love you guys. Thank you. This has been another edition of the Sweet Pea Diaries. Be sure to like this video, share this video, but most importantly, be sure to subscribe to the channel. And I'm out, y'all. Bye.